Hi, it's Jen Rubin, editor-in-chief of the Contrarian. Delighted to welcome back one of our primary contributors and certainly a contrarian, Andrew Weissmann. Welcome, Andrew.
Happy to be here
So,
as always. But although, today, this is actually, Jen, there's actually, as we've talked about, there's like good news from the courts.
exactly, there's good news in Wisconsin and now from the courts. Let's take us back to the beginning of Eric Adams' ordeal. He was indicted under 5 counts of serious felonies, including bribery, essentially having to do with foreign monies and foreign manipulation, indicted under a Democratic administration, the Biden administration. Then comes along Trump and take the story from there until really the remarkable results today.
Sure. Well, there were all sorts of reports about Eric Adams bending the knee and going to Mar-a-Lago and basically seeking or putting himself in a position to get a pardon. I don't really blame him for that. I mean, he's under indictment. That's what he's trying to do. I mean, he is also the sitting mayor of the city of New York, and so he has obligations as a public official. And that obviously is conflicting with his role as a criminal defendant. There were also some reporting about what may have been some greasing of that process by the current people who are currently, or at least a person who is currently in the Department of Justice at a senior level, suggesting how to approach Donald Trump to get this pardon. And this is what happens. Eric Adams doesn't get a pardon, which would be a flat out, this case is over. And we've seen what I would call all sorts of abuses of the pardon system. I mean, that's to say it's legal for what the president is doing. It is just a gross abuse of the pardon power. But that's not what Eric Adams got. What happened is the administration made a motion to say, we want to dismiss the case without prejudice, meaning that at any moment the case could be rebrought, essentially putting him on, I like to say, a choke chain. And so it is something that has him around the neck if he doesn't adhere to their policies. And that very much formed the basis of the decision today. But as people may recall, after we then heard about this motion, all sorts of hell broke loose at the Department of Justice. Senior people at the Southern District of New York that were handling the case resigned. Others were fired and removed. People at Main Justice, the head of the Public Integrity Section, and other people resigned. And ultimately, one person stepped up at the request, or should say at the command of the then acting Deputy Attorney General, that they needed a career person's name on the papers. God knows why, because when it was ultimately argued, no career person stood up on it. Instead, the acting Deputy Attorney General, Emil Bove, stood up and said, we want the case dismissed without prejudice. One other wrinkle before we get to what happened today with the judge's decision is that after what would I think maybe this is probably fair to say a shit show from the press and from the legal quarters, such as myself and many others, talking about how this is just absolutely an outrageous thing to do, to have the criminal justice system being used to exact this kind of obeisance of a public official to the federal government. You had Eric Adams then say, I make a motion now to have the case dismissed with prejudice. So, which is something he could have done weeks earlier, but hadn't done. So that was the state of play before the judge who was deciding this. He did get a so-called friend of the court brief, an amicus brief from Paul Clement, a very noted Supreme Court appellate advocate, very much aligned with conservative causes. but it's highly, highly respected. And he put in a brief saying that he thought the case should be dismissed with prejudice. And that was an option that the court could take. And thus, we then have the decision today from Judge Ho in the Southern District of New York.
Just to fill in a couple blanks, it was widely assumed, and in fact, I think the White House conceded that the help they wanted from Adams was on his draconian immigration policies. So now that we see people being snatched off the streets, shipped off without any kind of due process to hellhole prisons in other countries, that was the sort of help he wanted to extract from the mayor of New York City. And of course, that in turn led to calls for him to be removed by the governor, who chose not to do so. But other people in City Hall resigned because, of course, Adams had compromised himself. He was then under the thumb of Donald Trump. So Judge Ho issued this opinion. And it was interesting, not only because he took the brief from someone who wasn't a party, because no one was really arguing against this corrupt deal, but because he really went the extra step to get at what was underlying the motion to dismiss. What was your impression of the decision, of how Judge Ho handled this whole matter?
I think it is pretty masterful. I think that I'll leave one slight criticism to the end, but I think in terms of the result, I think it's all he really could do. Remember, there's no law. He would have been very much out on a limb if he had said, I'm not dismissing the case at all. And at that point, the federal government can just sort of slow walk the case. They can't sort of be forced to prosecute. So the case would sort of languish and go away anyway. He doesn't, in the context of this kind of case, which is not a civil contempt case, there's no precedent for the court to appoint its own prosecutor. And I think he really would have risked getting reversed if he had done that, because that is the prosecution function is really an executive branch function, not a judicial branch function. So his choices really were between dismissing with prejudice or dismissing without prejudice. And by doing it with prejudice, he is taking away the choke chain. It is certainly, many people could say it seems unfair. The sitting mayor of New York should have to have his day in court, that the public is harmed. But that's not something the court has the power to remedy. I would note that the crimes that are charged, the 5 crimes, are ones where there are state analogs. So one thing to watch is whether the DA picks this up. It would not be the first time that the Manhattan District Attorney has had to pick up a case because of, let's just say, the reticence of the federal government to go forward on a case. But that really wasn't an option for the judge here because of his role. So I think he did a really good job. I also think he did a really good job in protecting those people who resigned, who were being targeted by Emil Bove, saying they're going to be subject to an investigation. He went out of his way, I think, to make it clear that he had enormous trouble with what the government was saying and the actual credibility of what they were saying, and completely understood why people would not sign on to this deal.
Exactly. And this is not the first time a federal court judge has said to members of the Judicial, the Department of Justice, rather, representatives, that we don't really believe you, or we're having trouble with your credibility as presented. This seems to be now a pattern in front of federal court judges. Now, you did say you had one criticism. What was that of Judge Ho?
Sure, but I can give you a quote to your point about the credibility. In dealing with one of the 2 grounds that the government put forth as to why they wanted to dismiss without prejudice, one was sort of the appearance of impropriety about the timing of the case in terms of when it was brought. and the other had to do with this idea of the immigration enforcement rationale. And with respect to timing, he goes through it to talk about how this is entirely consistent with what's done and what happened here with what's been done in every case with DOJ policy. And he says, and this is a quote, all of this suggests that the appearances of impropriety rationale is not just thin, but pretextual.
Yes, a lie in vernacular.
So that is the segue to my one criticism, is that this is a very polite decision,
Yes.
and that and it's very scholarly, it's long, and this is my one criticism, because we're dealing with an administration that is so over the line in what it is doing and is making representations that I think are just not true. Just think about the Elon Musk, he doesn't run Doge, those kinds of things being said to two federal courts. I think to say all of this suggests, that's the quote I just read to you, it doesn't suggest it. I would say it demonstrates it. And that's sort of throughout the opinion. There's a lot of, because the judge didn't hold a hearing, a factual hearing where you had witnesses. There's a lot of language like that, which is that this shows why I have grave concerns, or it raises the specter, or it suggests. And I think that at some point, you know what, that you need to just call it out for what it is. And if you think that's what's, remember, you have a standard of proof, say what it is. You think it's preponderance or clear or convincing, but if you think that's what the evidence is, it doesn't suggest it, you find it.
Right. Now, what is interesting is I don't know that the administration is going to appeal this argument in this order. And perhaps that was partially why he kind of pulled his punches a bit. But before coming on, you made an interesting observation, which is this is a bit of a racket, to be blunt about it, that if they had pulled this off, they theoretically could have gone around the country to governors, to mayors, indicted them on spurious charges, they're not above that sort of thing, and then held it over their heads so that these people would do their bidding. And in a prior conversation, you pointed out this would be hugely damaging to the rule of law. Do you feel, at least on this grounds, we're now past this, that this will be a disincentive for them to try it again? Or do you think it's not beyond them to go indict somebody else and try to dragoon them into their immigration dragnet once again?
I do not put it past them. This is one federal district court judge. They have ample arsenal to be attacking judges when they make adverse rulings. And Judge Ho has a background that, I mean, I think is admirable, but it certainly makes him a bit of a target because of his work for sort of liberal NGO. But I don't think that it affected his decision is so rock solid. And so I'm not saying that to say that it affected his decision, but rather it gives more fodder for people who want to attack him. I do think I want to stress just how important this case is, because if it had come out differently, what you said, Jen, is absolutely right. That I gave some hypotheticals last time, which is, imagine that they just said, we will bring a case against you unless you give me $100 million. Or we're bringing a spurious case against you, which, by the way, we're allowed to do because under the presidential immunity decision, we can even bring a sham investigation and it's not subject to judicial review, at least in terms of the president's criminal immunity. And we will dismiss it if you vote our way. And so the idea that you can use the criminal justice system to make a political officer, whether at the federal or state level, your puppet is, I mean, if you think that they're using money and the bully pulpit to do that now, this would have allowed them to use the criminal justice system to do that. This is why you have the acting head of the Southern District resigning over this. You have career people in the Southern District resigning over this. You have the head of the public integrity section and the senior leadership resigning over it, because the people in public integrity do this day in and day out for a living. They understood just how subversive this would be. And it's what I love about the decision, with my one minor quibble, is that judge gets it. And the judge says that it is breathtaking, he said, what they had essentially the temerity to argue to him about what they wanted to do with the criminal justice system.
Exactly. And if it makes people feel any better, there are a few cards left to fall. One is, as you point out, the Manhattan DA might still indict Adams on a variety of charges. Secondly, the people who made this decision may be subject to bar charges. In other words, their professional ethics are now on full display and they may suffer. And the third, I will point out, somewhat unrelated, but perhaps not entirely unrelated, is maybe the Senate, and in particular the Democrats, but really the Republicans who have the votes, will put the brakes on confirming individuals. And today it was very interesting. Adam Schiff, senator from California, put the hold on the nominee for the DC U.S. attorney, who has been an absolute menace, threatening senators, threatening members of Congress, seeking all kinds of political and really inappropriate advantages, going back to events that are long since past. And Adam Schiff said, wait a second. We're not going to go forward with this. Ed Martin is his name. We're not going to go forward with this. So maybe, are you a little optimistic? Maybe that the Senate will have wised up and now be embarrassed by some of this behavior enough to at least pump the brakes on some of these nominees?
Yeah, and I think that's where something like the Signal Gate scandal does come into play, because it unmasks, it makes it so palpable and it's so resonant to the public what is going on, and it can, I won't say stiffen the backbone, but slightly stiffen the backbone of people who want to be critical and are more willing now to find their moments to push back. With the key being not just the Democrats, but finding the alignment with Republicans who still have a sense of decency. I should note, to your point about the Bar Association, we saw that in Trump 1.0, and then we've seen that during the Biden administration, where lawyers got into some hot water on that. Obviously, Rudy Giuliani being a sort of a prime example. But the judge does note in a footnote in his Adams decision that he thinks the filing may have violated the local rules about what you can say about a pending criminal case and the nature of the evidence and charges. And so I found that sort of interesting in terms of things to come. It is worth noting that in DC, that Pam Bondi's brother is seeking to have a leadership role, I think maybe the leader, in connection with the DC Bar. So for people who are listening to this, who are members of the DC Bar, you want to pay attention to that and see, look into that election. And I'm not saying which way to vote, but you should look into which way is important to you, because it is something where bar associations can matter in terms of both holding to people account and also not being weaponized in the same way that we are seeing other things being weaponized.
I think that's a perfect note to end on. I think what you just said, that bar associations suddenly have a role to play. We all have a role to play. Unfortunately, we've seen some law firms rise to the occasion, other law firms crumble, capitulate, kiss the ring, bend the knee, but it takes all of us to preserve the rule of law. So thank you, Andrew, once again. We always enjoy having you, even if we don't enjoy the moment. We enjoy the moments when we're on with you, put it that way.
Right, but today, it's nice to see a decision, I mean, where the courts, especially the district courts, have really continued as they did in connection with the claims of election fraud. They continue to be carrying the laboring oar and being a functioning part of what's supposed to be our tripartite system of checks and balances. So Jen, thanks so much.
You're very welcome. We can only hope that this show of spine rubs off on Congress, that they too recover their spine and decide to do their job. Thanks so much, Andrew. We'll look forward to having you next time. Bye-bye.